Top of the morning to you and welcome to the Legal Landscape. We're inside of Season 2. This is episode number 5, in case you want to know. And today's topic, we must remind you, is Landlord and Tenant, Recovery of Possession of Property. Now, before I introduce my guest, let me tell you, the vast majority of landlords in Jamaica would say that they have encountered difficult tenants at some point in time. There are tenants who do not pay rent. Those who cause damage to property, and others who refuse to leave when the landlord needs the property. Now, in those circumstances, many landlords believe that they are entitled to kick out those delinquent tenants. After all, it's their property and the tenant is in the wrong, they would say. However, is it really that simple is the question I'm asking. Can a landlord evict a delinquent tenant? Or what action can be taken to legally remove the tenant and recover the premises? Well, to assist us in this discussion and to understand this topic even better, we're joined at this time by Ms. Chantal Bennett, an associate at DunnCox Attorneys-at-Law. We say top of the morning, Ms. Bennett, and welcome to the Legal Landscape. How are you?
Hi, morning, Richie. How are you? I'm fine, thank you.
I'm well, thank you also, Chantal. And this is a very, very important topic that we're looking at this morning. First question for you. Can a landlord evict a tenant who refuses to pay rent?
The simple answer is no. Tenants are protected by law, particularly under the Rent Restriction Act and the Law Reform Landlords and Tenants Act. Based on the law, certain procedures must be followed by a landlord in order to evict a tenant who has not paid rent.
So what about other breaches? I mean, what if the tenant is causing damage to the property or causes a nuisance to neighbors, for example?
Yeah. Again, the tenants are protected by law. However, there are certain covenants which a tenant must follow. So, for example, a tenant cannot sublet the premises without the permission of the landlord, and they're also required to keep the premises in a sanitary condition. If the tenant commits a nuisance or annoyance to adjoining occupiers, that may be a ground for the landlord to initiate steps to recover possession. Mm-hmm. On the matter of damage to property, that is a little nuanced, and the landlord could consider suing for damages to property, or in terms of recovering possession, considering arguing that the tenant has caused the premises to deteriorate.
Mm-hmm. Oh, by the way, I just want to let the listeners know that we are in a very special and important segment, the legal landscape. Today's topic, landlord and tenant, recovery of possession of property. If you want to participate, if you have a question, you can always call us on 876-906-9557 or 876-906-9559. We'd love to hear from you, just in case you have something you'd like for our attorney-at-law, Chantal Bennett, to address this morning on the subject of landlord and tenant, recovery of possession of property. Continuing, Chantal, are there other grounds, though, in which the landlord may recover the premises from a tenant? For instance, what if the landlord just wants to just take back the property?
All right, so the landlord can't just take back the property. There are specific grounds in law on which the landlord must initiate recovery of possession. The other grounds, in addition to the ones we've mentioned earlier, are one, if the premises are reasonably required for the occupation of the landlord or someone who is dependent on the landlord. In addition, if the premises are required for the purposes of being repaired or improved or rebuilt, those are grounds on which the landlord can initiate steps to recover possession. But the landlord can't just decide they want to take back the premises without having a reason found in law.
So what steps should the landlord take then to recover the possession of that property?
Okay. So the first step is the landlord must serve a valid notice to quit on the tenant. This notice to quit must be served personally or can be transmitted by a registered post. I will go into what is a valid notice to quit in a minute or so. After the notice to quit is served, if the tenant does not vacate the premises within the period in which the notice states that they're to vacate the premises, then the landlord can file an action to recover possession in the courts.
Okay. So when he's recovering possession, what are the steps that would have to be taken? I mean, do they differ in terms of the circumstances where the property is, say, commercial or if it's residential property?
Right. So for commercial properties, a little different. The notice period, the notice to quit would be longer because, it's commercial property and the person is carrying out a business and they want to maintain the money and the income. So they under law, you have a longer notice period if you have commercial property as opposed to residential property.
Let's go back to the notice to quit, Chantal. What information should be contained in a valid notice to quit?
Right. So the notice to quit must state the legal ground on which the tenant is being asked to vacate the premises. And we would have mentioned some of those grounds before. So, for example, if rent is due for over 30 days, that's a ground. In addition, the notice to quit must state the period by which the tenant is required to vacate the premises. And this period must be appropriate based on the agreement or the type of tenancy that the tenant has with the landlord. In addition, the notice must be in writing.
All right. Very, very important facts you're sharing with us this morning. Now, it looks like my final question, really. When outlining the steps to recover possession, you mentioned that landlords may obtain and serve a court order. So my question right now is, what if the tenant does not obey the court order? Are there consequences for that?
Yes, there are consequences. So the judge will normally consider the matter, decide whether or not to make the court order. That order will be served on the tenant, and if the tenant does not vacate the premises within the period of time in which the order says he is to vacate the premises, then the landlord may seek assistance from the bailiff's office, and the bailiff will take whatever necessary steps to remove the tenant from the premises.
Interesting. Very interesting. I found this program to be quite interesting and very, very informative. Unfortunately,
Right.
time does not allow us to go beyond now, but we have enough time to ask you in closing, do you have a hashtag, did you know, for us?
Yes, sure. So one important point is after serving a notice to quit, if the notice to quit is in relation to non-payment of rent and the tenant pays the outstanding rent before the notice to quit expires, then the tenant can continue occupying the premises. So essentially, the notice to quit would no longer be valid once the tenant has paid that outstanding rent in the requisite period of time before the notice expires.
Chantal, you've been of a great deal of help. We thank you for the information you shared, and we wish you a beautiful day today. Thank you.
Thank you. Same to you. Have a great day.
All right, much appreciated.